guys, session 3 today, and today we'll be talking about the actual legal points in a construction arbitration. What happens, and when you guys are interning, when you guys are working as lawyers, this is what you will be required to do on a daily basis. Now, dispute resolution processes in construction arbitration. तो किसी भी काम में अगर dispute होता है, it's not just arbitration that people go in for. There are various other methods that people adopt, and these are negotiation, direct party to party. जब लड़ने की जरूरत नहीं है तो क्यों लड़े? Mediation, of course, assisted negotiation with neutral mediators. A person will be sitting there as a neutral person, hand holding and advising the parties. कि भाई लड़ने की जरूरत नहीं है ना? You come to a common ground, you walk 50 miles, you walk 50 miles and meet somewhere in the middle. Then conciliation, and again, mediation, conciliation, sort of same things, but have different provisions. There's a mediation act, conciliation is under the Arbitration and Conciliation Act. Then is adjudication. Now, adjudication is a very, I would say, new concept. और इसके लिए बहुत सारे construction contracts में there's a dispute adjudication board that is provided in the contract itself. So while the project is ongoing, the DAB will sit there and oversee everything. And the minute there's any problem or dispute arising, it's addressed then and there. So DABs play a very important role कि बाद में जाके long term कोई dispute को, if something is small and can be handled at that level, you don't need to wait for 5 years for it to become bigger and then you handle a bigger issue. So DAB के recommendations are usually binding because the parties have agreed कि we will use this mechanism to resolve our disputes unless challenged within a specified time period. All right, so that's DAB. And arbitration, of course, we know what arbitration is all about. We'll be discussing the various things involved in arbitration also. And अगर arbitration में भी कुछ नहीं हुआ, award आ गया, तो challenge करोगे ही, 34 कहाँ जाएगा? कोर्ट के पास. 34 के पास 37 जाएगा, उसके बाद SLP होगा. So it's another litigation and rounds of litigation. SLP, review, curative, nothing stops you anywhere. Now, guys, the DR dispute review boards is what we are looking at here now. And, you can read it here. I won't get into the nitty-gritties because it's similar to a DAB, what we just discussed. Okay? FIDIC contracts में provisions का होता है. That is why people adopt it across the sectors. And जो board members होते हैं उनको contractual immunity मिलती है. In FIDIC there are 3 people who have to sit on the DAB or the DRBs, and it's there to ensure neutrality. कि मान लो अगर if there's a tie between if one person is thinking something, another is thinking something else, so the third member will then have a veto. All right. Advantages होते हैं, proactive होता है, technical expertise होता है, because इनके जो भी members होते हैं ना, they are known to be experts in a field, who can deal with day-to-day issues that are arising in a project. So technically sound होते हैं ये लोग, तो as such issues are resolved very effectively here. And of course parties का जब dispute शुरू होते ही खत्म हो रहा है या एक provision है करने का, the relationship also continues. Ultimately, suppose I build flyovers and you are NHAI. हम लोग काम करेंगे life में, आज नहीं तो 10 साल बाद फिर से. So the relationship is also preserved. There's no किसी पे blacklisting का sword नहीं झूलेगा. All right, and cost efficiency, getting into arbitration, paying arbitrators either as per the schedule or as what the parties agree, going to court, paying court fees and paying lawyers and senior advocates. So cost effective. Now, guys, we come to, and before we go to the challenges here, FIDIC contracts में एक और बहुत salient feature होता है, engineers जो होते हैं उनका role. So the engineers are like PMCs, project management consultants, and they don't have powers that a DAB has, but they still have powers to address these issues at the very localized level. All right. So engineers here. Of course, traditionally they play a very significant role, but limitations होते हैं यहाँ पे. Can somebody tell me कि because an engineer is appointed by the contract, employer का agent होता है for the project. Now limitations क्या क्या हो सकते हैं? why do people usually don't prefer engineer-based resolutions or provisions that they
Lack of legal insight.
can legal, yes. See, also, what I said, employer the agent hota hai. So the other party will always feel a sense of bias or partiality, you know, कि वो यही बोलेगा जो उसका बॉस उसको बोल रहा है, वो क्यों नहीं बोलेगा अपने बॉस का बात. And of course, very rightly said, legal knowledge कम होता है. So balancing equities and natural justice principles. Suppose if there's a dispute, मैंने employer की बात सुन ली, मैंने अपना letter लिख के तुमको दे दिया, ऐसे होना चाहिए. When will you hear me? So natural justice. These are a few limitations. And then of course DRPs we have discussed already. Technical preservation, and then we come to adjudication here. Now see, adjudication is another concept which is internationally used very extensively. India में उतना है नहीं adjudicator का concept अभी तक. But you know, this is a standard adjudicator clause जो usually dispute resolution clauses में होता है. So like we discussed in the very first slide, there are steps. Negotiation होगा, mediation or conciliation, adjudication, arbitration, and then litigation. So this is about adjudication. This is a standard sort of a clause जो usually arbitrations में होते हैं. कि decision in writing होगा, not after a certain period of time. इतने में तुमको decision मिल जाएगा, so you have certainty and clarity as to what will happen. And final and binding hoga, if you want to challenge, you have to challenge within a certain time frame. These are the challenges. I think we have discussed this as well. See, we have to cover a lot of ground today, so I'm moving a little fast here because these are all logical, common sense things that you will face and see. Now, of course, in construction disputes, because we discussed CCADR here, I know technical expertise, legal expertise. There can be chances of partiality or biasness. So arbitration is preferred in case of a dispute. And you guys understand construction contract because the values are so high. Nobody wants to settle for this. So arbitration, of course, you get the formal award, which is, you know, can be enforced in a court of law. People prefer arbitration. Advantages क्या होते हैं construction arbitration के? Technical expertise hota hai because usually it's a panel of 3 arbitrators that's provided in the DR clause in any contract. I will nominate one, the other side will nominate one, and both of them will get a presiding arbitrator. All right. So impartiality hota hai, and because I'm nominating somebody, I won't nominate a Tom, Dick, or Harry. I will nominate somebody who's well versed with what my contract is about. I don't want a stupid person sitting here not knowing anything. So of course, technical expertise arbitrators के पास pass होता है because the parties also want to secure their claims. And the procedural flexibility होता है. So as we all know, arbitration is a child of the contract. The arbitrator has to work within the 4 walls of the contract. Arbitrator contract के बाहर जाके कुछ नहीं कर सकते हैं. अगर कुछ किए हैं, so that can be struck down in a challenge to the award. An arbitrator has to interpret the contract as it is written. कोई extrinsic interpretation लाके interpose नहीं कर सकते in in a contract or by dealing with the claims and counterclaims. All right. And the parties have procedural flexibility. The parties may agree that we want a fast track. We want to not need evidence. Documentary evidence पे based हम लोग arbitration conduct करेंगे. Because documents speak for themselves. And now confidentiality, of course, होता है because it's a private affair. And arbitration is a private affair. It's not before a court of law. आपका award जैसे court के website पे judgments publish होते हैं, publish नहीं होते. So many a times various government agencies are trashed by the court. How can you maintain this panel of arbitrator? It's a biased panel. Or how can your chairman act as the adjudicator or the deciding authority? Many judgments, starting from these till final, have come from the Supreme Court. And that's under common knowledge now. But in arbitrations, these awards are between the parties. So unless, of course, it's challenge and 34 countries and the order are there. Speed, of course, the parties can decide on the speed as well. And litigation से तो arbitration fast ही होता है because आपको dates का clarity है, ऐसा नहीं है आज matter लगा मेरा next day ना 5 दिन बाद कुछ नहीं है, right? And finality of course. So all of you I think are abreast with the Arbitration Act. 34 के grounds बहुत limited हो गए हैं. And courts now have a very offhand approach कि judicial intervention जितना कम हो उतना better है. And you know it's also stemming from the international good practices as well, which is a good thing. It's a step in the right direction कि businesses also have clarity. Yes, and ये छोटे से काम पे मैं award challenge हो जाए, I'm left in a vacuum. Now guys, so you see these grounds here, and before we move to the next section, party autonomy is very important in arbitration proceedings. Now, what is party autonomy, guys? Anyone, any pointers? What does it necessarily mean?
Since the parties have come to an agreement and they have considered that dispute resolution should be done by arbitration, so they should have the autonomy regarding the procedure, the timelines, and everything that is being governing the arbitration procedure.
Perfect. I think he has covered everything here. So guys, see, in an arbitration, unlike a court of law, I will decide the way my arbitration is to be conducted, the law that is to be applied, the seat of arbitration, seat being the most important thing, even the venue, the parties decide. So there's no hard and fast rule in an arbitration that has to be followed. So parties have a lot of space to move around and see what is suiting their convenience, which is another great thing, for any business running entity. And yeah, I think arbitrator selection also is very important. Party autonomy. If I'm before a court of law, I can't dictate my judge. No, I want it before that judge and not this judge. In arbitration, you choose your arbitrator. All right? And now, guys, how many types of arbitrations are there? See, usually ad hoc and institutional. Now, what is ad hoc? Parties decide, parties appoint. There is no institution governing anymore. But then comes institutional arbitration also, which we get into later. So ad hoc may, parties control everything and lower administrative costs because every institution takes administrative costs as well. There's a tribunal secretary that is appointed who takes care of the entire arbitration procedure and processes that are happening, who communicates with the parties, who tells the tribunal that, now you're supposed to do this and now this order has to be passed. And also, institutions like CAC and ICC, also after an award is made by the tribunal, the secretariat reviews the award. So the chances of challenge goes down and you get, I think, a more compact, legally compact award so that parties are rest assured that this is going to be the final step in my arbitration. All right? Now, guys, we go into institutional. We have already discussed what it is. In India, we have quite a few institutions now, and the leading ones are named here. One is DIAC, which is associated with the Delhi High Court. The other one is Mumbai Center for International Arbitration, and then we have the ICA, and you can just read about them here. All of them, try to deploy state-of-art technologies and try to assist the parties to the best of their abilities. And I also have a comparative analysis here in my notes. Probably you guys will get it after this session. So, MCI has very advanced digital tools. So what are these tools that we're looking at, guys? When you sit in an arbitration, maybe as an intern or as an advocate, you will see that the arbitrations have very specific needs. They want the entire proceeding, entire session to be transcribed. So who will do that? Transcribe. So, as we are talking, there is a tool and there is, there are agencies who do it, which is sitting with you simultaneously and whatever we are talking, they are jotting it down and speaking and minutes word to word. So that tomorrow, if there's any dispute or confusion, it can always be referred. So, MCI has those tools as well. MCI specializes in construction law, and has a lot of good experience in this field, also being situated in the commercial capital of India. So, construction, commercial, they are too advanced with it. And very strict deadlines, online case management we also have. Coming to DIAC, again, digital use hai, extensive hai. I won't say they are state-of-art technology deployed yet, but pretty good at digital usages. Arbitrator का एक panel maintain करता है DIAC, and whenever Section 11 is filed before the Delhi High Court, they take that list and say from the DIAC panel appoint this person. So they maintain a very robust panel of arbitrators, and it's segregated into different fields. So if say a dispute is regarding an oil rig, there will be people named under that head. So you know that the person adjudicating upon my case knows what he is doing, right? And digital submissions hote hain, everything is online, you don't have to file hard copies and run around, and strict timelines again. The ICA has very limited digital use till now. Construction expertise hai. They try to maintain impartiality because they have very strict impartiality disclosures. And fast track procedure we have, set timelines hai like any other. Now guys, moving to the international institutions, and I will suggest one thing at this juncture. Try to associate yourselves with either or maybe more than one of such international institutions. They keep coming to India, they keep holding conferences, they do arbitration weeks. Say, abhi, 2 weeks back was the Delhi Arbitration Week. And it was amazing. It was run by CAC this time, and ICC ke log bhi the. It was really amazing. To deal with them, to discuss things with them, and they offer courses as well. So many a times online, many a times in person, and very great crash courses. A day or two, and you will come out learning a lot of things, international practices. So do that, guys, if you get time to. So yes, the popular ones are CAC, ICC, LCIA in London. Now LCIA also has a young international arbitrators group, YIAG. I started associating with them, I think more than a decade back, and then you then deal with the main institution also, and now we invite for various things, of course, so as time person can go. But and of course HKIC is again, because Hong Kong is also a commercial hub. So Singapore wants itself to be the arbitration destination for everyone. Like Maldives is a honeymoon destination for everyone. Alright, so Singapore again, pretty streamlined. There are very efficient people handling things, and the arbitrators also are not the ultimate authority that I'll do whatever I want to. So because the Secretariat also reviews all these awards once drafted by the Tribunal. So it's a second layer of stamping on it, on various grounds. Now guys, there's also provision for emergency arbitration. Now what is an emergency arbitration, if anybody has any?
For example, dispute is about a land. Somebody, the owner is selling that land. So it will defeat the subject matter.
Very well.
Section 9, essentially, when
So that was my next question. Why not a Section 9? Why will you go in for emergency arbitration?
So emergency arbitration is certain kind of a deviation from the traditional arbitration. So certain time with respect to the timelines and the procedural hearings, for example, oral and documentary evidence. So there are certain deviations from the traditional arbitration. That is why we go for emergency.
See, emergency is before your tribunal actually stands constituted. So when the parties are nominating and exchanging these conversations, when two people are sitting together and nominating a presiding, and the presiding is giving its consent, its disclosure of impartiality and whatever. So that is when emergency steps in. And institutions handle it amazingly well. It's time bound. Within 30 days, you have a resolution in your hand. And the moment you invoke it, there's an arbitrator, an ad hoc arbitrator that's appointed for the interim while, and you get what you need. So again, a very preferred choice. And then many times there are international parties involved. So say one party is sitting in New York, the other is sitting somewhere in Hong Kong. And how do you come to a common ground? This is where these institutions step in. And they say, don't worry, sit wherever you are, we are managing it. all right? So that is emergency arbitration. And also, these days, a lot of DR clauses, and you see I'm using short forms, I hope you are now well versed with it. DR clauses have a multi-tiered dispute resolution clause. Two parties coming together, wanting to do good work for profit. They say कि देखो dispute होगा, तो पहले ऐसे करेंगे, then we'll do this. If not resolved, then we'll go for that. So this is what happens. Parties give a timeline to each other. In case of a dispute, you'll notify me within so many days of the dispute arising. And this we'll try to resolve by negotiation within so many days. If it's not done, then we'll go for mediation. And mediation का भी timeline fix होता है from 2 months to 3 months. And then, of course, there are a lot of expert determinations for technical issues. So a lot of contracts from various government agencies I have seen that they appoint a consultant who's sitting on top of the project. And people say that this is the expert regarding 1, 2, 3, 4, 5 points. And if any of those points lead to a dispute, we go and take an adjudication from him. Of course, it's not final and binding. Parties can always challenge it. And of course, then arbitration. All right? Agar usse bhi resolve nahi hua, one party is not satisfied with whatever the concerned consultant or the person is saying, then of course you have to go arbitration and go to the formal methods. And all of this, why are we discussing all of this? कोई भी जब business करता है, तो उसको dispute mind में नहीं होता है. Everybody is working for profit. Timeline, काम खत्म करो, आगे बढ़ो. But of course, sometimes disputes cannot be avoided, and all these processes ensure early resolution, if possible, and business efficacy between the parties. Another very important concept, right? Now this ends up with session. So I hope this was clear. Let's see, this is all common sense. There's not much we can talk about it. If you have any ideas, feel free. Anything else that we missed here discussing? Think about it. If you have any ideas, you can always connect with me later on as well. Now we come to arbitration अब तो invoke हो चुका है. Now, what is a case management during an arbitration proceeding? Of course, again for efficiency, adhering to the timelines and giving parties that clarity in their mind. Right? This is how a case is being managed. It's being done fairly, impartially. This is a timeline. You will get an adjudication. Arbitrators are not biased at all. So this is all about case management. And ultimately, documents filed होते हैं. There are various drawings and sheets that are submitted, AutoCAD के sheets. How will you maintain that? Who will maintain that? Who will keep a record? Who will ensure that the record is not being tampered with? There are various things in the case management which we now see. Yes, so see, case management also is important for controlling costs because the arbitration can't go on endlessly and you can't have endless procedural hearings. So for controlling cost, managing schedules and ensuring fair proceedings like we just discussed. Now, why is a case management so important when it comes to these heavy duty arbitrations is what I'll say. Number one, document intensive holding. Once you start working on any such matter, you will see earlier, before COVID, you were still working a lot with hard copies of files. So many a times the whole room was filled with one arbitration document. All right. So of course they are document intensive and technical complexities बहुत होते हैं because yesterday I told you guys when you enter into this field, you will not just be a lawyer. You will become everything else. So technical complexities बहुत होते हैं which also need to be managed. Multi-party involved हो सकते हैं. It can be employer, contractor, subcontractor, consultants. There can be many parties. So managing so many parties together, of course, needs a procedural framework and clarity so that nothing is going haywire. And again, the quantum issues. How do you define that? Case management also really helps in that, which I'll come to later. So yes, so now pre-arbitration case management पे चलते हैं. When you are working with any lawyer or a law firm, or client आया है मेरे पास that this is my dispute, I want to invoke arbitration. These are the documents. करो काम. What is to be done there? So early case assessment deals with that. What all will you do? Document management strategy बनाओगे. Establish document retention protocols since the project started. Then create systematic filing systems for easy retrieval. And many times there are, say, 4 lakh documents. And if the arbitrator wants a specific point to be addressed, what we do? So we make filing systems, in an Excel or in a project file, under different subheads, and maybe one document can fall under 10 heads, but I know that this head has this document linked. So that, of course, electronic document management system, which I just discussed with you guys, and reviewing the documents to identify key evidence. Many times there may be letters saying, hey, let's meet tomorrow, okay. We don't need that per se, unless there's a minutes of meeting that you require. So identifying what is the key evidence here. And just because I have to file something before a tribunal, I can't file any trash. I have to see that whatever I'm filing is relevant for my case as well. Now, and when you are doing an early assessment, what all do? You risk assess as well. See what is the strength of my client's case, what is the weakness of the potential litigation, identifying missing documents and maybe seeking them from the client. Dude, this particular letter refers to 3 minutes of meetings. I don't have them. Give it to me because they may be relevant. All right? And assessing the quantum implication and also settlement possibilities. So as lawyers, I know we all want to do good bidding and good matters, but when it comes to justifying your work for the client, we always believe if there is a possibility for an early resolution for a client, we must suggest. All right, and this is coming from being officers of the court as well. And why not assess possibilities as well? So that is your early case assessment. And then, you have initial management conferences with the client to discuss, decide, do various things. एक framework बनाते हो ना, उस framework में क्या आता है? Arbitrator appointment. Client तो आ गया आपके पास कि भाई, this is my case, this is my dispute. Please invoke arbitration. What all will you ask your client? You will give possible names of arbitrators who have expertise in that field or who are known to be fair, unbiased, and good at what they do. What are the preliminary issues? So, I may identify something but the client is sitting at the project level. उसको हो सकता है 10 चीजें और पता हो जो from a initial review probably I couldn't look into it. The client will give you suggestions and then you discuss with the client. Of course, strengths and weaknesses as well. Case schedule बनाओगे, communication protocols बनाओगे. Now I'll issue a notice invoking arbitration, as we all know. फिर क्या होगा? दूसरी बात reply करेगी, अपना accommodation देगी. And what will be the communication channel? Will I do it on behalf of my client to the other side or to their counsel? How will all of this work? This is all about early case management. Now, yes, and at this time, I think people also discuss on the requirement of expert evidence, the number of expert evidence that we need to lead, the procedural timeline and scheduling that we are looking at. And this is all just for clarity. This is establishing the base with your client. And then, of course, you invoke arbitration. Well, that's time management principle. So, guys, I hope all of you have read the 15 amendment. There's a timeline prescribed कि arbitration इतने दिन में खत्म होना चाहिए जब से pleading complete हो. So this is all about that. All right. So as per the Act, the standard timeline is 12 months. We all know from the date of completion of pleadings आपको award आ जाना चाहिए. अगर नहीं होता है, then the parties can mutually agree and give a 6 months extension to this arbitration proceeding that's ongoing. और अगर उस 6 month में भी नहीं award आता है, then you have to go before the court under section 29A(4). All right, and then the court decides whether the tribunal's mandate is to be extended or not, and if extended, should any terms and conditions be put or not. Many a times, court, arbitrators का fees कम कर देंगे. So it's a deterrent even for the arbitrators to do it within a certain timeline. अब actual timeline है तो there has to be some teeth to enforce those timelines as well, no? So yes, sir, these are the typical timelines, okay, that we are looking at. Arbitration start होता है, statement of claim file होता है. I hope you all know. उसके बाद क्या होता है? Now you guys tell me.
So statement of claim is filed by the claimant.
Yes.
Statement of defense is filed by the respondent.
And any counterclaim, if any, yes.
Counterclaims. And then a reply to the statement of defense. And then they issue.
Then, a rejoinder and a reply to the counterclaim. And then the respondent also gets to rejoin to my reply to the counterclaim. Yes. And then?
And then any kind of objections and the issues are prepared by the arbitrators. Then the
उसके बीच में एक और step. When the parties have each other's pleadings in front of them and say because say I am an employer and you are a contractor. हो सकता है कुछ documents बस आपके पास ही हो सकता है कुछ documents बस मेरे ही custody में हो. I can always go in for discovery. All right. So documents. Yes. Then.
and then
Very well. So issues frame होते हैं. Then list of witnesses file होते हैं. जिसमें factual witness होता है, expert होता है, technical भी बहुत बार होता है. And then of course, chief, cross, and you move on to your final argument. So that's what happens typically in an arbitration proceeding. These are बहुत सारे applications. So keep that in mind. And a hearing and then the award. And this is a typical usual timeline. No hard and fast rule here, though. Now, you know, as we discussed already, this is, I think, an overview of everything. Pre-contractual documents देने होते हैं हमें, which are those pre-contractual tender documents. So when you bid on an as-is basis of whatever is in the notice inviting bids. So tender documents चाहिए होते हैं, pre-contractual correspondence चाहिए होते हैं, which is any letter of intent, any clarification that we have sought and we have received a response from the other side, any addendum to the tender documents, there are various things. Site investigation reports, very important again. When a notice inviting bids is circulated, the contractor, whoever wants to bid, is told, "Bhai, this is the site, go and inspect. Beware of what you're getting into." So site inspection documents again are very important here because ultimately काम तो उस site पे होना है. And I will bid. I will say, okay, fine. My bid is 200 CR. वहाँ जाके पता चलता है उधर तो land ही नहीं है, उधर तो पानी बह रहा है. So site inspection again are very important. Feasibility studies and approvals, if approvals are in place, there are pre-bid meetings also that usually are held. Usme people ask questions. Are the approvals in place? If it's your responsibility, what is the timeline that we are looking at? Very important. You know, this is all common sense and logic. Think from the perspective of a person who's going to bid. If you're going to get into some work, you will want to ensure that the base work is there. And I'm not getting into something that I have no idea about. So that, and then we come to contractual documents, of course, the main contract, the tech specs, as I discussed yesterday, the general clauses, the special clauses, schedules, bills, BOQs. BOQs are another very important thing. Have you guys ever dealt with a contract of this nature, by the way, in any of your internships or you have? Has anyone else as well? So, you know, now, whenever you're going to intern next time onwards, are the team to involve you in some arbitration, construction or not, read the contract. You know, it's very, initially you will get a little lost in your head, but with this background, I'm sure that you will be able to navigate and help yourself with a lot of information as to how is a standard contract functioning and what is required to be done. All right? And then, of course, performance documents. So this is pre-contract, contract. Then, काम शुरू होता है. Performance documents, minutes of meetings, progress reports, the site diaries, which is usually signed by both the parties, representatives of both the parties. That today there were 50 people working on the site, signed. And it's a day-to-day basis का progress report that comes in. minutes of meeting, I told you, change orders and variation instructions, like we discussed yesterday. Scope change ho sakta hai, price change ho sakta hai. You should, and this is when the work is continuing. You should definitely ask for these documents, payment certificate and invoices. Ultimate goal is money, right? Anybody is working for money in such contracts. So, how much payment has come in? What is the actual billed amount? And how are things working? And then, of course, सारे claims तो वहीं से आते हैं. If it's LD, it'll be cut from your running bills. Whatever invoices you have submitted, they'll say, sorry, we're not giving you so many. Such part of your total invoice value. And then, technical documents also very important because it is on this that expert evidence, technical experts come in. So the drawings, the approvals for the drawings, the changes that are required to be made in a certain drawing or something that you have submitted. So many times the contract says the drawing should be as per this condition. But when you actually submit it, they come up with a new condition, which is not recorded anywhere. So that will be a dispute. So you must have all these, the quality control and testing reports. Testing reports are another very important. Whenever something is constructed, you have various kinds of tests. You have performance guarantee, PG tests. And usually these tests are conducted by IIT professors and people who are big experts in the field. So all these testing reports become very important. The material certificates, of course, that I'm not using substandard material to safeguard your own self, safeguard your client's interest here. Warranty, safety, and environmental compliance records. Another very important fact, like we discussed yesterday, the regulatory requirements. Now, guys, this ends here. And, well, so now for everything, what is it that is required for you to start working on such a matter? Number one, key personal list. Project पे कौन था, किसका क्या role था, दोनों sides. So you have clarity. Every letter, every minutes of meeting, you will find names there. Sometimes signed by somebody, sometimes referring to somebody, sometimes attended by a few other people who are all named there. You as their lawyers must have clarity on who are the people who are actually at the project site, what happened, and who wrote what, and to whom. Alright, so key personal list. Chronology of events again. Inception se leke jab tak dispute hua. What is the chronology? What are the important events that I must put into? Glossary of terms, okay, now talking about the technical challenges in these technical heavy contracts. You must know that what is a JP term form, what is, the various terms that come in. And you cannot just be a lawyer, all right? So technical clarity you need. And summary of dispute and the parties' positions, which you will find from the correspondences, all right? That will form the crux. And usually there's something called schedule, or something that we usually refer to for our convenience as well. Ki what is the claim? 1, 2, 3. उसमें मेरा क्या position है? As per the correspondence, दूसरे side का क्या position है? And what is to be determined by the tribunal. So if you have this clarity, you will initiate your arbitration with a much, much clearer lens. And you will be able to assist the tribunal more clearly, is what I'm saying. Now, another very important fact here that comes in is managing multi-party contracts and multi-contract disputes also. So what is multi-party, we all understand. What is a multi-contract dispute? Many a times I have back-to-back contracts. Like, there'll be a master contract wherein I am the contractor, and the master contract will ask me to appoint subcontractors for certain jobs. So it's a back-to-back contract, and we see multiple contracts here. Another situation, I'm supposed to build something, then operate also, and then transfer it, BO, BOT. So in such situations, there are two things that arise. Consolidation. Contracts, 2 हैं, 3 हैं, 10 हैं, we consolidate the dispute and make it one arbitration proceeding. And mostly all these institutions have a provision for consolidation. and joinder of additional parties. Now, what are additional parties? Why do we require additional parties? Anyone? You are the contractor. I'm the employer. Why do we need additional parties? What's the concept behind it, if anybody knows?
So that all the disputes can be resolved under the same table.
And just because of delay, like any dispute that is arising is because of the matter of the additional contractor.
Incidental works that have happened or incidental compliance that has taken place that has led to some delay or disruption.
Can be, yes.
Can the group of companies.
Exactly, that's what I was looking at. You know, Spox and Kings give us a lot of clarity on what to do, how to do. 5 tests there, okay? Now, I have a claim against you. You are a special purpose vehicle, actually owned by, say, the Adanis. I have to have the parent company brought in to realize my claims. Otherwise, I'll have a paper award. Who will I enforce it against? If all your funding is coming from a certain person, if you are just created for the purposes of this project, and you're 100% owned by somebody else, some entity, I should have a right to do that as well, right? And if in my contractual negotiations and performance, that entity has been pretty active, then I will include, all right? Because then that entity also becomes a necessary party during evidence as well. So yes, another point. And guys, see now usage of technology. I think your generation is way, way better than how we were in our times. But technology and arbitration, anybody any idea? Okay, see, COVID has taught us a lot, and we were all working on hard copies before it. Now we all have Liquid on our iPads, and Liquid is something that works before code source also these days. So technology, you know, everything has to be on a virtual platform to give parties that ease as well. If somebody is sitting somewhere across the globe, technology helps. આજકાલ everything is virtual, you know, even cross-examination is being conducted virtually. A King's Council is sitting in London, crossing a person from Singapore. It's just technology has taken it to of course another level. Now, of course, advantages हैं. Travel, accommodation, cost reduce होता है, increased flexibility होता है, that you don't have to be physically present somewhere, and you can sit wherever across the world and just ensure that your arbitration is proceeding as per the agreed timelines. Environmental benefits, of course, carbon footprint goes low, and accessibility, of course. But there are challenges also. And anybody, there are challenges. So also technical difficulties, you know, many times an app crashes, your camera doesn't open, and if a witness is not on camera, how do you know somebody sitting next to the witness and including the witness? Right? So credibility of a witness also. And then in such situations, document handling also becomes an issue. So these are the cons that what you could think of. And then time zone coordination. So for us, it's like if a client is sitting somewhere, time zone coordination also becomes a very big issue here. And you know, now what are the tribunal's power in case management? It's there. So see, interim reliefs, of course, you know, once you recognize the issues, and if you need an interim relief to protect the subject matter, of course, you'll want the tribunal to conserve various things. And, you know, also give a partial award or an interim award to protect the subject matter. Document production, the tribunal can definitely order, and as part of case management, you know, once we go in for discovery and inspection, the tribunal can, of course, anytime say that, you know, this party you're supposed to produce this, and if you do not, adverse interest will be drawn against you for that. Expert appointment कर सकता है tribunal, and you know, expert usually एक party करती है या दोनों parties मिलके करते हैं, and the tribunal can also appoint for its own clarity and understanding. The tribunal has that power as well. And procedural directions, of course, is what the tribunal provides in a case management system. And that ends the very cumbersome logical topic of case management. All right. So I hope you guys have understood. Any questions still here? Any questions still here? Case management, anyone? I know you will, I understand that it's all pretty theoretical right now, but once you work on an actual mandate, then you will realize that all of these are basics that you need to know before you jump in. Otherwise, you'll be lost. Somebody was just mentioning headless chicken. JSA, you don't want to roam around when you are, actually sitting and doing this work. Because you want to do your best. But how will you do your best if you don't have your basics clear? Now, guys, session 5, evidence, hearings, and avoids. And when we're talking about avoids, we'll also talk about the challenges and enforcement. All right? Now, evidence, सबको पता है क्या होता है? Can I assume that? All right. Court में भी होता है, arbitration में भी होता है. But arbitration में the Evidence Act doesn't strictly apply. But principles always do. CPC and evidence. In an arbitration, principles always apply, but it doesn't strictly apply that as per order-based, rule-based, you have to propose, right? Because ultimately it's the parties' autonomy and flexibility. Whatever they decide will prevail. And the tribunals also have a very broad discretion in admitting evidence. So that power the tribunal has. There are various international best practices that are usually adopted. And many tribunals prefer cross-examination to go in a statement manner. Many tribunals prefer it in a Q&A manner. So it totally depends on how the tribunal is also advising the parties and what the parties are also agreeing. Now, it will be very strange for you to hear a statement of cross-examination. So what happens here? A question is asked, and of course, the question can't be readed. So a question is asked, and whatever the witness is responding will be just recorded as a statement and run into pages like a statement. So witness is basically reiterating whatever is in his affidavit, but not in so many words, a form and manner. So you see, or अगर lawyer ने भी बनाया है, the witness is now giving his own statement. इसमें कभी-कभी suggestions आते हैं. Suggestions क्या होते हैं? So the party who is examining the witness will put its case to the witness. And now, internationally, this is being dispensed with. People don't want suggestions to be put to a witness, but traditionally, many old practicing senior advocates still put suggestions. So these are suggestions that are put. And also, relevance and materiality. If your witness is just talking about everything except the main issue, it makes no sense. So the tribunal can always ask the witness to not digress and answer to the point and issue. It has to be relevant, it has to be material evidence, all right? Because nobody has time to talk a whole story. And now, how many types of evidences are there, guys? So, of course, documentary evidence hota hai, which is the document speaks for its own self. Admission denial bhi hota hai iske liye. And many a times you deny receipt, deny contents, accept receipt. So these are all the ways in which you admit or deny a document. That's another step before you proceed towards framing issues. Hearings are complete, AD hota hai, right? And then documentary evidence. And document management which principles hote hain, which is chain of custody, authentication, chronological organization. Once you start working on it, you will understand, and this will be all clear then. I mean, it must be a lot of jargons flowing on top of your head. And then we have witness evidences, which is when a witness presents itself with a statement on oath that this is my statement, true and correct, and I am here to present before the tribunal, and I am here to be cross-examined. And witness statement में क्या-क्या होता है? Of course, एक affidavit होता है. Examination in chief होता है बहुत बार. Many a time the tribunal examines in chief, that this is my affidavit, sign and this at this page, and this is my signature, I have drafted it. And many a times a lawyer does it, many a times the tribunal does it. Cross-examination or re-examination. Alright? So many a times if I feel that my witness was asked a question which was very tricky, and the witness probably got confused and maybe has not answered it correctly, I can re-examine my witness on that particular question, on that particular point. Or if I want a point to come out more clearly, I can put questions to my own witness as well. That is a re-examination. And then comes expert evidence. Like we were discussing, expert evidence, technical grounds pe hote hain. I can call for it, you can call for it, or the tribunal. And these are usually, industry experts that come. And Alvarez and Marcel, Grant Thornton, Kroll, all of these are experts in this field. So in many of our arbitrations also, we get these experts to testify. And usually these experts coming for delay analysis, damage quantifications. So another, of course, very vast area and field. So technical experts कौन कौन होते हैं? Engineers, architects, construction specialists. Delay experts कौन कौन होते हैं? जो programming और project management में involved रहते हैं. Otherwise, what will give you that sense to even, bifurcate everything and see delay आया किधर से? Who are quantum experts? Yes, quantity surveyors, cost analysis wale analysts and CAs of course. And then comes legal experts. So many a times, international arbitration is specifically when a contract can be interpreted, a clause can be interpreted in 3 different ways. People invite legal experts as well to give the best possible interpretation pertaining to that sector at that given point in time with their expertise. So legal experts as well. And then what are the roles and functions of an expert witness? क्यों लाओगे किसी expert witness को, paying them lakhs and crores of rupees? Why? It is an added cost.
Explain complex issues.
Definitely, yes. Professional inputs, industry standards. In assessing damages, in applying the various formulas that exist internationally, okay? So the delay analysis there are 6 kinds of formulae that are there. The SCL protocol that I was discussing yesterday, it's all there. And which formula is to be applied, how is it to be applied, what factors are to be kept in mind, can only come from an expert in that.
Ma'am, I have a question.
Yes.
Are these expert evidences binding or are these just opinions? Because under the Evidence Act or the BSA, they are not binding.
See, so in an arbitration, again I told you, evidence doesn't strictly apply. What happens here is, a person, who are the factual witnesses, the people who have been associated with the project at site or sitting in their office, dealing with all the correspondence day-to-day communication. When an expert steps in, the expert steps in with a lot of experience and is usually a very well-regarded person. So if something is coming from an expert, the tribunal will consider it. Ultimately it's all about, in an arbitration, balancing scales and common sense as well. So finding it also depends on the tribunal. But if somebody is giving compelling evidence and compelling expert opinion backed by a lot of data and research, because that's what experts do. Not following it is something that will make your award perverse. Opening it for challenge. So that's the answer to your question. If it's binding or not. Ultimately, it's between the parties. Whatever we decide. And arbitrator, of course.
Party appointed ही होता है.
Party appointed होता है, tribunal appointed भी होता है, as I told you. So the tribunal can also call for an expert. If the parties are at loggerheads, agar I got an expert, the other side got an expert giving 2 different views. What do you do then? The tribunal appoints. These are all scenarios, different permutation, combination, anything can happen. But ultimately, to arrive at a very logical and sound conclusion. Everything is done for that, right? Now, guys, selection of and appointment, of course, I think we have discussed this. Singly appointed, jointly appointed, many times, parties to reduce cost as well. Because sometimes an expert's fee can go into CRs. So, you and I sit together and we say, well, listen, there should be a loggerheads. The tribunal wants clarity on this and we have to provide clarity. The documents are definitely not clear on this. Let's appoint an expert, usually. Internationally, बहुत होता है ये. Indian context, I have seen it, not that raging. Yeah, people don't trust. So now, yes. These are the things. Independence and impartiality, of course, the expert is there to tell the tribunal true and correct technical facts, technical grounds. It's not there to serve any party's claims or purpose. So that must be kept in mind. Okay? And an expert, when he steps into that shoe, is not there for any party. Okay? Now, before we move to the hearing procedures, there is some essential requirements of an expert witness also. So, if you have appointed an expert, or if other party has, or the tribunal has appointed an expert, what are the key elements that should be in an expert report? And these are, any good report will have an executive summary at the top of it, summarizing whatever the expert has come to the conclusion for, of, why, what, where. All right? The scope of work, the scope that is given to the expert. Now, if I am appointing an expert for delay analysis, वो quantum में नहीं जाके देखिएगा. तो scope clearly defined होना चाहिए that I am an expert for this particular issue and this particular point, or these issues and these points. Factual basis has to be set out very clearly. It cannot be contrary to the facts on paper. Otherwise, the entire expert report will go over the video. So factually, it has to be very sound. Technical analysis का especially section होना चाहिए because उसकी expert है. Otherwise, legal problem भी expert. Documents are there. Conclusions should be very clear and with their opinion and recommendation as well. And of course, supporting documents, supporting references of if they're using a particular method, a particular formula, where is that being derived from? If it's still upheld or some new formula has replaced it, it should be a very sound report. Standards hote hain, clarity and precision. And the better the expert, the more of these points you will find. Clarity and precision, logical structure and flow in the expert report, supporting evidence flow, and professional format, of course. So this is how an expert report should look like. Many of you might go and maybe work as an independent litigator or work in the field or join a law firm in the lit team. Many of you might just go and join, say, GT or KPMG or somewhere, in their legal departments. And when you are there, you have to do this. Because these guys conduct audits, legal audits, forensic audits, and they do delay analysis, quantum analysis. So these things will be important if at all any of you are going that way. Now, guys, going to our next section. Hearing procedure and construction arbitration, another very important thing. And I think I'd rather want you guys to tell me, whatever you see, क्या होगा pre-hearing. Suppose you are, I'm your client, you are my lawyer. Pre-hearing preparation क्या करोगे? I'll expect certain level of work from you. What all will you do? You will organize my documents. You will create a pleading that covers all the issues involved, that supports all the claims that I am raising, gives a logical support to everything. Chronological होना चाहिए, cross-referencing होना चाहिए, witness statement बनाओगे, documents of course review करना ही पड़ेगा ये सब के लिए. And of course, prepare for cross-examination is something that, again, is a very thin line. You cannot tutor your witness. Facts are facts. You cannot mold it to be something else. But of course, guiding the witness on how to go about it is something that lawyers do. We don't sit and tutor, prepare a witness, but we of course guide the witness and handhold and take him in the right direction. alright? Because not everybody is a legal expert. Sometimes technical people need assistance. And as lawyers, you only provide that assistance, right? Now, yes, bundle preparation, witness preparation, hearing management. Now, hearing management में क्या होता है, guys? So suppose hearings are complete, everything is filed, process done. Hearing, क्या करोगे आप hearing में as lawyers? Opening statement होगी. When you are before a tribunal, you have to tell the tribunal what your case is about. So there will be an opening statement by all or both the parties. Then factual evidence, expert evidence lead hoga, and many a times you need to visit the site because sometimes the project is continuing, but dispute is not here. Sometimes the project is over, but people are claiming that see it was such a bad work that look at my site's condition. There are site visits also that take place. And then of course, after all of this, the closing arguments. A closing argument may have, of course, final argument, advance, and a tribunal, before a tribunal is a very informal setup. You don't stand and argue like this. It's a round table, you sit, you present your arguments, you have an opening submission, which is a brief note of your entire case. So whatever you're going to argue, point-wise, that you present to the tribunal. So that tribunal is with you. Like, PPT here, whatever I'm saying, you guys know what we are discussing. And after arguments conclude, you submit a final written submission. Many a times, we also put the entire data of the cost that is incurred. Because that is the point when the tribunal will be able to award you the cost of the proceedings also. उसमें क्या क्या जाता है guys? Lawyer's fees, venue fees, पूरे arbitration में जो बिठाने के लिए खर्चा हुआ है सबके, whatever I've incurred, and if I'm the winning party, I pay to the tribunal. You grant me entire cost of the proceeding because no fault of mine, my claims are succeeding, the other party should pay the cost. Very, very, very importantly, in Singapore, when if my claims are defeated, I have to pay cost to the other party. If I succeed, the other party has to pay cost. It's a mandatory thing. So it also deters parties from raising these frivolous, unreasoned, baseless disputes against it. Very important here again. Yes, now witness examination, of course we have discussed this. You guys want to go through it again? Examination, cross-examination, re-examination, supplementary questions. Many times tribunal you have questions which have their clarity. Suppose if my witness is being cross-examined by someone, witness kuch answer kar raha hai, question kuch aur hai, the tribunal can definitely put in a question. And how is it written? It's called PER tribunal, per tribunal. So many a times the transcript of the deposition, you see per tribunal. What does that mean? It's from the tribunal side. Right? For questions for clarification also. And yes, that is there. In expert, of course, there are various things that are used. Of course, experts are not legal. So they simply come, they talk about the technical jargons in plain language, of course, for everybody to understand it plainly. Visual aids they use a lot, they may use a PPT, they may use pie charts and graphs and different statistical data for everybody to understand. Methodical approach hota hai and reference materials, of course. Okay. Like if an expert is referring to a certain method in the SCL protocol, that SCL protocol will be the reference material, which will again be circulated amongst everybody or can be a part of the expert's evidence itself. And expert ka bhi cross-examination hota hai, which is, of course, quite logical. And yes, an expert should usually be composed, clearly explain their stand. Evidence-based response hona chahiye. You can't speak, anything and everything without any basis. What they have written and backed by evidence, that should come as an expert. Telling you because you might go that way as well. And an honest recognition of constraints that the expert has also faced. Many a times, an expert makes various assumptions while coming to a conclusion. That should be very honest, right? Now, guys, going to the fun part of things. You guys want a 2-minute break or something?
Yes, ma'am.
Please, yeah. I could figure that out. I also want water. 2 minutes, guys, and then we'll quickly build the fun parts. Guys, I've seen too.
क्या है भाई?
अभी नमक चेंज होगा।
यही होना है
यही होना है।
भाई सुपारी
पत्ते में
पान है, सुपारी है। अच्छी टीम दे रहा है। अच्छी टीम दे रहा है। नहीं मैं आपको
फर्स्ट ईयर फर्स्ट ईयर कोई नहीं है ना
कितने निकाल रहे हो? आप मेरे को इतना
ठीक
गुस्सा आ
है।
गया।
कर भाई फर्स्ट ईयर
2 राउंड है, पता है ना?
हाँ
हाँ,
कितने बजे
दूर
5:30 तो खत्म हो जाएगा।
ठीक है।
आप दोनों का। दो अच्छी टीम होंगी।
अरे जिसको
आप दोनों को एक ही साथ बेंच पे लेंगे।
हाँ
मर ही जाएगा।
कल
अरे मार देना जान से मार देना।
अरे रोते रोते नहीं निकला
मुझे इनके रूम में टाइमर बना दे। ओपन इवेंट्स में मुझे इनके रूम में टाइमर बना देना।
मैं बैक पर
तो बैग ही में
सर मैं ऐसा ही मैं अपना चश्मा साफ करनी कुछ और थोड़ी ना देख रही हूँ मैं कहीं सपना अपना
मैं भी कल
अरे मैम सही में मैं बीच में जो बोल रही थी मैं आपको देखते हुए चलो यही देख आया भी कितना मस्त था अपना एकदम प्रॉपर ऐसा
कल भी पिंक कलर का साड़ी पहन के हम थोड़ा एक्सपर्ट एविडेंस पे डिस्कशन करते हैं। नहीं मैं देख रही थी
देखने वाली चीज और है, वो
उन्होंने व्हाइट कलर का समथिंग इयरिंग पहना है और
पर्ल
वाइट
वाइट
है रेड है उस पे अच्छा सा बना है।
लिपस्टिक भी लाइन में लगी
अरे,
एक इंच मैम मेरी चश्मा इतना साफ है फिर भी मैं तीसरी बार साफ कर रही हूँ कि मैं और अच्छे से उनको देख पाऊँ क्योंकि मैं पीछे बैठ गई
पिक्चर ले ले भाई लाइक लास्ट में कमेंट कर देना
वो दिखा रही थी अगर मैं स्क्रीन छोड़ रही हूँ मैं स्क्रीन देख नहीं रही हूँ मैम क्या खाली देख रही है तो आप
सब समझ आ गया मुझे आर्बिट्रेशन का अब तो मेरा
बात कर रही नहीं
कौन सा कहते हैं
What's KPM? Is this the KPMC she was talking about? The expert opinion sheet.
क्यों पिछली बार तो नहीं पहने थे आप लोग हमारे टाइम
व्हाट डू यू मीन आप लोग मैं तो
5 बजे तक ही तो आप लोग मतलब 5 बजे टाइम रहता है
हाँ 5 मिनट थोड़ी देर ही और चलेगा।
वेरी नाइस मैम आप थी एमसीसी में मतलब हमको फॉर्मल्स पहनना पड़ेगा
नहीं
अब कल भी आना।
नहीं यार
हाँ, टी-शर्ट में
याद है अच्छे से कि जो बने थे वो नहीं पहने थे
रनर टाइम
ज्यादा हो रहा है तो व्हाइट टी शर्ट ही पहन के
मैं फॉर्मल्स के बाद नहीं पहने थे
रनर टाइम को नहीं पहनना
नहीं तो नहीं पहने
क्यों
कल
पहना?
क्लास के टाइम
पूछ
पे
रही हूँ बता रही हूँ
यार
यार
जजेस भी तो नहीं पहनते
हाँ,
जजेस भी नहीं पहनते हाँ एग्जैक्टली सिर्फ पार्टिसिपेंट्स मार्किंग इसका हो रहा है कि तुम्हारा हो रहा है
जजेस तो वीडियो
अरे मैम जैसे सामने से हो रहा है भाई ऑफलाइन है ना मेरे को याद है मेरे फ्रेशर स्क्रिप्ट टाइम पे एक जज से बैठे हुए थे, मतलब एक बार मैसेज
मुझे फ्रेशर्स स्कूल की कोई याद ना दिलाए, मुझे शिवेंद्र सर याद आ जाते हैं, मेरे में वही मुझे तो थोड़ा सा उन्होंने स्टेज पे जाने से पहले ही इसको तो पक्का दिलाऊंगा, फिर वो
एक सेकंड
हाँ भी मेरा पहला स्टिकर पहला स्टिकर उसको jurisdiction से
फिर उसके बाद वो उठ के मेरे में क्या हुआ था, अनिश्चित सर आ गए थे बीच में, ठीक है, और वही फिर एकदम हमारे पहले फिर आई गेस वो चली गई
पर मैं रोई नहीं थी लास्ट
फिर वो हमारा सेकंड राउंड में था मेरा
मस्ती का आपस में की जोक मार रहे हैं
रितिका मैम कल
वो सीधे बट लेकिन वो घुमाते हैं पिटने की तरफ डालते हैं। हाँ उन्होंने मुझसे एक क्वेश्चन
मैंने
पूछा,
फिर से
एक
बोला
क्वेश्चन मुझे घुमाया, मैं बार बार
सारा
बोल
टाइम
मेरा
और
ये
जिधर उन्होंने
बोले गौतम है, गौतम सर मेरे प्रिंसिपल वो अच्छे क्वेश्चन। हाँ मैं काफी
सर एक क्वेश्चन मैं बता रही हूँ
Independent commercial.
यही है just because किसी से literally हो रहा है कि मैं किसी को अच्छे से कर रही हूँ इसलिए मैं भाई इसमें शेयर मेरा पहला दो ही कॉन्स्टिट्यूशनल पे है ना, इसलिए 20 clause 3 and 21 first two है उसके facts। ठीक है भाई, अच्छा है बट मुझे और समझ चाहिए यार। पढ़ते हैं पूछते उतारते नहीं है कि वो मुझसे 2-3 क्वेश्चन ही है और बस मैं जस्टिफाई कर कुछ नहीं है भाई, मैं तो कुछ
तो मेरे को ऐसा लग रहा है कि मैं जाती
Everybody's up. Now done with the procedural part of things. And now we come to what happens when it is refused. What happens? You get an award. But many a times during the proceedings also you get awards, which are partial in nature, which are interim in nature.
so like similar to orders that we receive in a court.
Can say so. Yeah, like interim orders, determining a certain claim that requires determination at that point in time, determining an issue of liability, but not the quantum at that stage. Alright? So all these are the various types of awards that you see here. Interim awards that you get during the course of the arbitration. इसमें क्या क्या आते हैं? Procedural, which are usually on jurisdiction, admissibility, and the procedure of course and other parties. You have partial awards, which are deciding specific issues or specific claims, like I just mentioned. Okay, इसकी liability है. And later on, liability थी, इसलिए what is the amount, the quantum of payment that has to be made to the other party. And then the provisional awards, which are temporary measures pending final resolution. Again, you know, sort of a section 17 or a 9 that preserve the subject matter that are required to be passed in a particular proceeding. And then comes your final award. Now, final award is the final determination by the tribunal. It has to be a reasoned award. Without reason, nothing floats in a court of law. It has to be, and you know, sometimes you get summary awards also. But summary awards are clear-cut, concise decisions on the issues that are already decided. All right? And then you have consent awards also. Suppose during the course of arbitration, you and I agree on say various issues or the entire dispute, then the tribunal will pass a consent award. It can be recording that two parties have agreed on issue 1, 2, 3 in this manner. So this is a consent award on those lines and for those disputes. And many times parties reach a settlement in the course of arbitration itself. And the settlement agreement is presented to the tribunal or maybe not presented to the parties and then the parties have arrived at a settlement and tribunal grants the consent. Very interestingly, I was attending an arbitrator's training course from Seattle during the door. And on consent award, 2, 3 things emerged. Now suppose you guys are acting as arbitrators. And if two parties come to you and say that we have arrived at a settlement, you stamp it and give us a consent award for the disputes. As an arbitrator, will you blindly just say, okay, fine, you have arrived at a settlement, cool, stamping, consent award? It can be against the law. It can be evading taxes and various other statutory liabilities. So how should an arbitrator act? There were, of course, different views on it, but think about it. It's a very, I would say, mind-churning thought that you will probably evolve while thinking about it. And now, guys, an award, a good award. What all should it have? बहुत बड़ा dispute है, technical issues involved हैं, arbitrators हो सकता है, technical experts हो सकता है, नहीं हो retired, judges हो, yeah, retired, say, CMD of some organization. What should a good award usually have? Number one,
the issues.
Yes. Addressing issues, of course. Number one, factual findings. The facts should be presented correctly. Because facts are facts, but they're born out of the record. So, facts clearly stated. Disputed facts क्या क्या है clearly stated हो. And हर एक fact का determination. Because if there's none, it will be an unreasoned award, non-application of mind. Again, a very good ground challenge. 24. Legal analysis होना चाहिए. What are the applicable laws and what laws will apply to the facts of the present case? So that interrelation should be there and legal analysis should be very clearly put down because anything perverse is again a ground for criticism. Alright? Quantum assessment, so calculation of damages and compensation. As we were discussing yesterday, there can be no penalties. Alright? That can be imposed on anybody. So compensation should be there, a reasonable compensation should be there. And what is the ground and basis for you to arrive at this calculation of compensation? You can't just guess.
And from this compensation, is it also regarding the fee of the arbitrator and other things, like cost of arbitration?
That is a separate portion altogether. Compensation usually is other dispute, the claims and the counterclaims. LD, liquidated damages, unliquidated damages. Sometimes the contract prescribes for it. That LD will be imposed at this rate per week of the day at a cap of 10% of the entire contractual value.
Adjudication cost is exactly like the same amount it's paid.
It depends totally, if the tribunal thinks that it's reasonable and whatever is demanded stands the test of law, then of course it's granted. And then we come to interest and costs. Now interest, rates, cost allocation, the tribunal has to apply its mind. Many a times, many contracts bar payment of any interest. But we have many recent judgments which show that the tribunal still has the power to grant interest, penalty, light, and so on and so forth. Alright? And of course, enforcement provisions. I give you an award saying that wonderful, you have 100 CR in your favor, awarded. Very well. What are the enforcement procedures? Who will describe that? Of course, the tribunal. The arbitrator is not required to write that, go in under section this, before this store, or whether assets are located, go and enforce your award. But there should be a direct nexus to the enforcement provisions also. Alright? And Now we come to quantum determination. There are various valuation methods which we were discussing. And this applies to an arbitrator writing a final award or an expert. So keep that in mind. So there's a contract rate basis, which means whatever has been agreed in the contract, and for similar work, what would have been the rate. To arrive at, that computation that we were discussing, that should very clearly set out as per the standard rules and norms. The market rate analysis. Many a times work is done, maybe extra work is done, how do you calculate it? You will see what's the current market rate today for that particular work. Then there's cost plus approach, that's the actual cost that is incurred, plus what should have been the profit margin. And then there's quantum merit, of course, which means जितना काम हुआ है उसके वजह से आपको मिलेगा. This is going from the contract. Alright? Now delay and disruption calculations, there are various formulas. And all these formulas, people write books on each. So these are various formulas. You can write, not getting into nitty-gritties. You want to understand, connect with me offline for this. All right. There's Hudson, there's MDEM, there's Eachley, there's actual cost. All right. Now, please. What will you do now? I have an award. It can't be a mere paper award sitting in my locker. I want money ultimately, whoever is the winning party here. So what do you do then? Types of award, आपको पता है interim होते हैं, final होते हैं. And enforce करने के लिए आप क्या करते हैं? Firstly, what we usually do is when we get an award, if it's in my favor, my client's favor, I write a letter, formal letter to the other side. That this is the award. The award says that this payment has to be made to me within 30 days. If not, this amount of interest rate will apply on the total awarded sum till actual payment. So write to the other party, please comply, please give the money. In the meanwhile, the other party has a right to challenge the award under 34. And what are timelines under 34, guys? Yes. Okay, fine. What all years are you from? First years? Second? Third? Fourth? Fifth? Great. Very good. CC Prasad. So, I'm 30 with a reasonable submission was why you could find it in the timeline. So, if the other party challenges an award, my award is not automatically stayed. I can still enforce it unless there's a stay by court while hearing the challenge. And if there's a stay, my enforcement is also stayed. What happens here? Usually, when a court is seized of a Section 34 challenge, it asks the party who has preferred the challenge to deposit the entire or some amount for it to stay the award, stay the operation of the award. Usually in Delhi High Court, the common rule is 50%. Till some time back, Niti Aayog came up with a circular requiring a 75%. But it is important also that fine, we hear your challenge, but it's an arbitration that both of you agreed to. You have gotten a determination. How long can it go on? So the awarded sum must be preserved. All right, that is the whole concept. And if a challenge nahi hai, so after the statutory period of filing 34, you can file your enforcement petition. Now, where will you file it?
That depends on the competent jurisdiction basis, the territorial jurisdiction where the seal and the after award has been given. So, for example, if we go for a seal in Delhi, India, if the award has been passed by the arbitrators in India, so it will be enforced in the commercial courts of the competent jurisdiction, based on the pecuniary value of that arbitral award.
Okay. Now, I have one question for you. Follow up for that. Suppose I got an award against Mr. X. Mr. X operates out of Bombay. All his assets are in Bombay. Where will I file the enforcement? see, so for enforcement, you can also find it at the places where the assets are located. All right, it can be UAE as well. All right, so that is another very important aspect here. And now, when you're talking about a 34, what are the grounds? We understand, 34 with the recent amendment has really confined the scope of a challenge. So these are the few grounds available, and usually courts do not want to interfere in an award, because ultimately in India still we have retired judges of the High Court and Supreme Court who are good names in the industry adjudicating such disputes. So what are the limited grounds here? It should strike on the face of any fact or an unreasoned award. Yes. Arbitrary non-application of mind, which is very apparent on the face of it. Recently, there was an award that was struck down by the Singapore courts, passed by a retired judge from India, Supreme Court, because it copied a few of his earlier awards verbatim and some, I think, 200 pages or something. So, yeah. So, such that was supposed to be non-application of mind or perverse, to say so. And even the clauses were apparently incorrectly mentioned there. So this is something that, of course, the courts won't tolerate. Now, what are the grounds now? Incapacity. If the parties were incapacitated somehow. Now, what are incapacities here? Suppose I was never served notice of arbitration. I was never communicated by the tribunal that I should come and present my case. Or, yeah, I was not a party and the award is passed against me. Yes, definitely. And if the agreement itself was invalid, procedural violations, so denial of opportunity to present my case, excess of jurisdiction. Now, suppose if the arbitration agreement only refers certain kinds of dispute to arbitration, and the arbitrators or the arbitrator has gone forward and adjudicated everything that it wanted to. Now, that is beyond the arbitrator's jurisdiction. An arbitrator is a creature of the contract. It has to work within the four walls. All right? Arbitrators' misconduct, of course, another very important factor. There can be corruption, there can be bias. Suppose the arbitrator has been one of the parties' employee or has been their consultant or their advisor through and through. So there tends to be, a very, an apparent bias in a human mind. So bias and procedural irregularities, which I think, for example, suppose if I am given 6 weeks to file my pleadings and the other party only gets 2 weeks, despite making requests, that is a procedural irregularity on the face of it, no? Of course. And then public policy violations, which we all know public policy, very wide term being interpreted by courts through and through in different manner, what will be public policy. So there are various judgments, of course, on this aspect. Indian public policy principles, of course, for Indian awards. Now, recent developments in enforcement. So in 2021, the court's power to stay enforcement on fraud and grounds of corruption came in. That was unconditional. And for stay applications, a lower threshold was prescribed. And retrospective application. So you remember when the 2015 amendment came in, it was not retrospective. It was supposed to be brought into a picture from a certain date, October, I think, I'm not sure. So this had retrospective application. And these days, how is the judiciary interpreting the act or whatever is happening in the arbitration scenario? Hands-off approach. We won't interfere unless it's required. So, and the concept of public policy, of course, these days Supreme Court has really narrowed it down as well, saying that not everything can be public policy. It has to be weighed on a very narrow lens. Minimal intervention, like we discussed. Judicial restraint is always the way, and especially, courts which are seized of commercial matters these days, especially the Delhi High Court, the Bombay High Court that you see, the judges are very well aware that, if you want to make India an arbitration hub, we have to stop courts from protracting litigations between parties. Because either party that uses will want to avail all possible legal remedies. And the court's role here becomes important. And, commercial certainty in respect of, and courts are very well aware of this, that businesses, if are wanting to come and invest in India, they want certainty on timelines, on getting their money. But if Indian courts do not adjudicate because of the burden of the number of matters that are there, or because of the circuitous manner in which challenges go on and on and on for so long. So you have to balance between enforcement and fairness. Fairness comes from the public policy angle, which we all understand. Now guys, here, there was a case law that came in very recently. The DMRC damages, the Delhi Metro Rail Corporation and the Delhi Airport Metro Line. Arbitration went on for years. Thereafter, challenge went on for years. A 34 was filed, a 37 was filed. Then an SLP was filed, a review was filed, and in the curative petition, everything was overturned and you're back to square one. So this was something that was not appreciated worldwide. And many legal experts also commented that this doesn't show business efficacy. Because ultimately you will have one ground on which the court will overturn everything at the last one. So DMRC damages to read it okay. Because various issues were discussed, including breach and cure notices, the period that's involved, how do you issue a breach and cure notice, and what are the punch list items that were open, closed. These are important, jargons that you keep using in construction arbitrations. So, yes, of course, very important here. And then we have a few other important case laws in this field which hold ground. Sanyong, Satluj Jal, Hindustan Petroleum. I am showing this to you on the PPT screen because, just take note of it. Read it when you have time. These are long judgments, but when you read it, you'll get a lot of clarity. All right? And now, any questions? Anything that you guys want to discuss? Any important aspect that probably we missed out? Yes?
Is it true that the quality of arbitrators in ad hoc arbitration, they mostly retired judges होते हैं, is somewhat less equipped to deal with the modern cases compared to institutional arbitration? Like आपने बोला कि CPC और evidence act के provisions strictly नहीं apply होते हैं, but ऐसा है कि वो लोग बहुत ज़्यादा strictly apply होते हैं क्योंकि वो उनका judges का जो होता है वो बहुत trial litigation based approach होता है तो arbitration में, तो उसके comparison में institutional जो arbitration है तो वो better serve करता है. Like how true it is.
I get where you're coming from. So see, this has been an ongoing debate for a very long time. Every arbitration conference that you sit for, this issue comes up. That how well equipped are the arbitrators? Should we have a technical list of arbitrators also? And why are Indian entities and parties who are, especially doing domestic arbitrations here under Part 1, why do we always want a retired judge to be an arbitrator? This is an issue that has been ongoing. And see, not all judges are so, I would say, unaware of the fact that how are international principles working, what are the international standards that usually are used in arbitrations also. Many judges, of course, still, I think, when they're new or when they come up with a very set principle in their mind, are hard to deal with. But of course, when you discuss with them and you present case laws before them and tell them that, these do not strictly apply. So you cannot ask us to do things in a certain manner, not in a certain manner that the parties want to. They usually understand. But of course, this is something that is an issue and will be for some time. But in India, we are also now promoting a lot of new age arbitrators who are lawyers, who are practicing professionals, like the DIAC. In the extensive panel that they maintain, anybody who has a practice of more than 10 years can enroll as an arbitrator. And the High Court actually appoints them. So I think we are taking steps in the right direction. It takes some time, but things are changing. And now, another very important factor, because the Indian arbitration scene has been rapidly growing since, I would say, the 2015 amendment. Things have changed a lot. Judicial intervention has been curtailed a lot as per the Act itself. Mandatory deposits, everything happening. So, and many institutions are getting more and more interested because India is a growing nation. There are a lot of things happening here, and disputes will arise. People are also interacting with CAC, ICC, HKIC, LCIA. People are showing interest. They all have offices here. And when you sit and interact and when you start having these institutions handle your arbitrations, you also learn and develop those international practices, which you then also implement in your ad hoc arbitrations. So, of course, it's an ever-changing field, it's changing, but I think we are taking steps in the right direction now. Yes.
You have mentioned that after arbitration only demand, there is a review process on that. Secretariat.
Yes.
Can you give clarification to what is the process of secretariat? But the secretariat review can secretariat turn the decision if he finds out, or if he turns, that means the pura arbitration process goes invalid and the secretariat has the power.
So what happens is the arbitrators write an award and hand it over to the institution. The institution reviews it on factual accuracies, on content not being copy-pasted, not being AI generated, on the legal aspects, so that in case there's a challenge, this stands the test of law, your aptitude to that particular application. So what happens to it? Ultimately, the institution reviews it to make it a good and strong award that in case of a challenge, it's not challenged. Now, what are the grounds in 34? So if the arbitrator has taken one view on a particular dispute, and if two views are possible, the court still won't get it because arbitrator did not take the other view. All right. So the tribunals, so the institution's job is to ensure that whatever view has been taken will stand the test of law, will pass the legal thresholds, making it less susceptible to challenge.
Can you tell me the difference, or I'm not able to know that adjudication and arbitration में क्या difference आ रहा है? Because I get the point of arbitration, but I believe after knowing all this, that arbitration process is still very tedious, because construction contracts, you have still 12 months, 15 months of time. What would be the relief you got, even if considering that emergency arbitration provisions hai? But still, I believe that the adjudication process आपने बताया था, can it still be a better option than arbitration?
See, now what happens is, if you and I are having a dispute, we definitely want our dispute तभी हुआ है जब चीजें हद से ज़्यादा आगे गई. Otherwise, we would have sat and talked on site about things. Adjudication, though being provided in the contract, still has no legal framework monitoring it, governing it, or backing it. It's still an agreement between the parties. All right? Though it is said that it's binding, the adjudicators award, and you have to challenge it within a certain time period. I will say parties and people prefer arbitration still is because of the legal and regulatory backing that it has. And of course, the procedures prescribed of challenge, of enforcement, and various things associated with it.
The process is so much tedious.
See, so now, what happens here is, if we are having a 500 CR dispute, whatever award I get, I want it to be legally valid. Adjudication still has no legal. It's not governed by any law. So I think to have more clarity on whatever you get in your hand actually being enforceable, or if you don't get it in your hand, then what is my next step? I think comes with arbitrations, this clarity. Anything else, guys? So we're good? Perfect. Thank you so much. You guys are very patient. It was lovely talking to you guys. And any queries, even if you are thinking about something, reading a judgment, feel free to get in touch with Thank you. Please clap for us.
Shalini.
Is he an online
दूसरा एक पेज में निकालो, ये नहीं चाहिए। मैंने तुमसे किसने बात की? मैंने जब 3 बार की आगे बात हुई है सारी।
Needs to be done by 15,
This is what we are eating and this is what we are doing.
A very good evening to one and all present here.
as we come to the end of this 2 days workshop on construction arbitration and practical practices in India, it is my privilege to give vote of thanks to ma'am and to all the participants. Firstly, thank you everybody for being here for a long time and being patient and hearing to all of us. I want to state that all the participants have been very engaging and active throughout the session, and that makes our session very engaging and throughout working. Secondly, I want to thank Manu sir for always being helpful and always being motivating us to include all these sessions and go for all these things. And I want to thank Shalini ma'am for being here and explaining such different topics and practical things in such real life example, including all those things. Ma'am, these things are going to help us in our internship and overall in all our upcoming years. So I want to personally thank you for that. Giving us this insight was very, very thankful. Now I would want to invite Dr. Rishikesh Manu sir to come here and say a few words.
Thank you. First of all, I think I must thank Shalini for coming here and engaging this 2 days workshop on construction arbitration, which is a very complicated but very high stake area. I teach arbitration law in this university, and I always believe that along with the academic learning, it is also important to understand the practical insight. So I think I was told that workshop was very effective in providing all of you that insight, and I think it must be very engaging, and you must have cleared all your doubts also from ma'am. So I think on behalf of the faculty coordinator of CCADR, I would also like to invite ma'am for our future events also, including I think next year in the Feb we are having a national mediation competition. So good thing about Shalini ma'am is that she's from Patna, so we can call as many times as we can. So definitely I would like to have you. And also I think yesterday I was listening to her bio, and I was told that she's also engaged in national green tab. So I'm also teaching environmental. So on that front also we can call for the environmental law lecture. So with that, I thank you again to Shalini and all the participants who have made this program a great success. And I hope that in the coming days you will learn, and you must have got some very important practical insight. That is a very, because we are always talking about the placement, and this workshop must have helped you in getting some very important lessons. Thank you very much.
Thank you so much, sir. Thank you, ma'am. To conclude the event, we had 5 sessions in total. The first session began with the introduction of construction arbitration as a practice, and then we dwelled into deep topics, talking about different type of claims and all type of how the arbitration process actually functions and how the awards are stated and how you enforce these awards. So this has been the total conclusion of the session or 2 days workshop, and I'm very thankful to ma'am for coming here and giving your gracious presence here in the university. We would like to collaborate with you, ma'am, for our future events as well. Thank you so much, ma'am.
Thank you so much, guys. Have a great weekend or whatever you have to wait. And all the best to your exam examinations.
Thank you.
Exam clear again.
Good.
नहीं मैं अंदर नहीं बैठूंगा
Everyone, please assemble there for the
कुछ तो हूँ भाई
Yeah,